The court will determine support based on full financial disclosure, including trust income. That was the sentence that made the billionaire's hand tremble. But I'm getting ahead of myself. The day he offered me $5 million to make it go away, he thought he was closing a problem. He didn't realize he was opening a case file. I was 6 weeks pregnant with twins when his assistant called. Not his son, not him. An assistant. Calm voice. Manhattan number. Ms. Walker, Mr. Caldwell would like a private meeting. This concerns a sensitive family matter. I've been called into briefing rooms in Afghanistan with less ceremony. I'm a Navy SEAL. 20 years in uniform. I've jumped out of planes in the dark and sat in silence offshore waiting for the word to move. I don't startle easily, and I don't intimidate easily either. But I knew what this was about. His son Andrew had been seeing me for almost a year. He was 42, divorced, educated, polite in that well-practiced way men raised in wealth often are. He liked that I didn't treat him like royalty. I liked that he seemed tired of being treated like property. When I told him I was pregnant, he didn't panic. He went quiet. That should have been my first warning. The meeting was at his father's office on Park Avenue, 32 floors up, private elevator, the kind of carpet that swallows footsteps. Mr. Caldwell stood when I walked in. Early 70s, perfect posture, silver hair cut with military precision, though he'd never served a day in uniform. "Lieutenant Walker," he said, extending his hand. He knew my rank. "Retired," I corrected him. We sat. He didn't circle the issue. He slid a folder across the polished mahogany desk. Inside was a check for $5 million, already signed, along with a non-disclosure agreement thick enough to stop a bullet. "There's also a medical appointment scheduled for tomorrow morning," he said evenly. "Discretion has already been arranged." Discretion. That's what he called my children. I didn't touch the check. "I assume Andrew spoke with you," he continued. "He is not prepared for fatherhood. His position in several corporate transitions makes this unfortunate timing." Unfortunate timing. I've buried men younger than his son who never got the chance to be fathers at all. "What exactly are you asking?" I said. He met my eyes without blinking. "I am offering you security, $5 million, immediate transfer, in exchange for confidentiality and resolution." Resolution. He didn't threaten me. He didn't raise his voice. He spoke the way men like him always do, like the world is a spreadsheet and every problem has a line item. "You're asking me to terminate the pregnancy," I said. "I am asking you to consider the long-term stability of all parties involved." That's when I smiled. Not because I found it amusing. Because in my line of work, when someone underestimates you, you don't show them your hand. $5 million, I asked. "Yes." "And that's final." "It is generous." I nodded slowly. "All right." He blinked. "I'll accept." For the first time, something shifted in his expression. Relief. He thought it had been too easy. That I was practical, that I understood my place in the hierarchy of his world. "Very wise," he said. Wise? He had no idea who he was talking to. I left with the folder under my arm and stepped out onto Park Avenue. The wind off the East River cut through my coat. I stood there a long moment watching yellow cabs inch through traffic. $5 million. For silence. For erasure. That night I didn't call Andrew. I didn't cry. I didn't rage. I pulled out the business card of a family law attorney a fellow SEAL's wife had given me years ago after a custody dispute nearly broke their family apart. Her name was Margaret Ellis, 63, former prosecutor, calm voice that carried authority without noise. She answered on the second ring. "I was offered $5 million today to end a pregnancy," I said. She was quiet for exactly 3 seconds. "Are you safe?" "Yes." "Do you want the child?" "Children," I corrected, "twins." Another pause, then, "When can you come in?" The next morning was the scheduled clinic appointment Mr. Caldwell had arranged. Instead, at 8:15 a.m., I sat in Margaret Ellis's office in downtown Manhattan. She read the NDA carefully, page by page. "They're asking you to waive all claims to paternity, child support, inheritance rights, and future disclosure," she said. "And this clause here, this is broad. It prevents you from ever speaking about this relationship." "He thinks it's generous," I said. She looked over her glasses at me. "Do you want $5 million? "I want my children protected." She leaned back. "Then you don't sign this. You file first." Explain. In this state, once paternity is established, child support is calculated based on income disclosure, including trust distributions and corporate compensation, for high net worth individuals that can exceed what they're offering. How much? She gave me a number. It was more than 5 million. Over time, structured, enforceable, transparent. And here's the key, she said. If we file before they try to move this into private arbitration, it stays in family court. Public record. Judicial oversight. Control. That's what this was about. He thought he could control the outcome before it ever reached a courtroom. Margaret closed the folder gently. So she said, "What would you like to do?" I thought about the men I had served with, about responsibility, about standing your ground even when the terrain shifts under you. I thought about 2 heartbeats that had done nothing wrong. I smiled and said yes, I told her. But I didn't mean to the clinic. She gave me a small nod. Good, she said. Then tomorrow morning we walk into family court. And somewhere across the city, a billionaire was about to learn that not every problem can be handled with a check. The morning I was supposed to be at a private clinic on the Upper East Side, I stood in line at a metal detector inside Manhattan Family Court. It smelled faintly of floor cleaner and old paper, fluorescent lights, plastic chairs bolted to the ground, no marble floors, no private elevators. Just ordinary Americans waiting their turn. A young couple arguing softly over visitation schedules, a grandmother holding a folder thick with school records, a construction worker in boots staring down at a child support notice like it was written in another language. This was real life. Margaret stood beside me in a navy suit that had probably seen more courtrooms than I had deployments. She carried a slim leather briefcase and the calm of someone who understood procedure the way I understood mission planning. "You're sure?" she asked quietly. I nodded. I didn't grow up wealthy. I grew up in Ohio in a house my father built with his own hands after leaving the Marines. We didn't waste food, we didn't waste words, and we didn't walk away from consequences. When I told Andrew I was pregnant, he'd looked stunned but not unhappy. "I'll talk to my father," he'd said. That was the mistake. Because in families like his father's don't just give advice, they make decisions. Margaret reviewed the petition one last time. "Petition to establish paternity," she said. "Motion for court-ordered DNA testing. Request for full financial disclosure. Filing date today." Once it's stamped, I asked. "They can't bury it in private arbitration. We're under state jurisdiction." That was the part Mr. Caldwell hadn't anticipated. Men like him operate in controlled environments, boardrooms, mediation suites, private settlements with confidentiality clauses stacked like sandbags. They avoid courtrooms the way I avoided landmines. Public record changes the power dynamic. As we stepped forward, I felt something settle inside me. Not anger, not fear. Resolve. I wasn't filing for revenge. I was filing for protection. Margaret handed the clerk the paperwork. The clerk glanced at it, typed something into a terminal, and stamped it. That sound, the heavy thud of a government stamp, was louder than any check sliding across mahogany. It meant the matter was now before a judge. Outside, Margaret made a call to a licensed process server. "They'll be served today," she said, "at the penthouse." I almost felt sorry for the young assistant who would have to interrupt Mr. Caldwell's morning meeting. Almost. As we walked down Center Street, Margaret explained what would follow. In high-income cases, she said, child support isn't symbolic. It's calculated based on verified income streams, salary bonuses, trust distributions, dividends, equity compensation. And if they try to hide it, the court can subpoena records. Judges don't appreciate games. That was another thing Mr. Caldwell had miscalculated. He assumed I wanted immediate money. $5 million sounds enormous. To many people it is. But over 18 years, 2 children, private school healthcare, college tuition insurance, structured trusts, the number shifts. More importantly, it becomes enforceable. A one-time payment buys silence. A court order creates accountability. When I got back to my apartment, my phone lit up. "Andrew." I let it ring once before answering. "What did you do?" he asked. His voice wasn't angry, it was shaken. "I filed," I said. I was supposed to disappear quietly." Silence. "You don't understand," he said finally. "My father is trying to protect the company. I'm trying to protect my children." They don't need court. We could settle this privately. You mean on his terms? He exhaled slowly. He thinks this will become public. It already is. Another silence. I didn't want this to get ugly, he said. It doesn't have to be, but it will be legal. That distinction matters. Ugly is emotional chaos. Legal is structure. After we hung up, I sat at my kitchen table and placed both hands over my abdomen. 6 weeks isn't much. No movement, no visible change. Just potential. I thought about the offer again. $5 million. For someone raised without money, that number can feel like salvation. But I've seen what happens when people take the easy payout. No enforcement. No oversight. No guarantees. And children, especially children born into wealth disputes, deserve guarantees. That afternoon, Margaret called. They've been served. How did he react? According to the process server, she paused. He went pale. I closed my eyes. That wasn't satisfaction. It was confirmation. For the first time, the situation was outside his control. The hearing date would be set within weeks. DNA testing ordered. Financial disclosure deadlines issued. No more quiet arrangements. No more assistant phone calls. Just a judge in a black robe and state statutes that apply equally to janitors and billionaires. That's something people forget as they get older and wealth accumulates. In this country, the law doesn't vanish just because you've grown accustomed to influence. That evening, I received one final message. Not from Andrew. From Mr. Caldwell himself. 3 words. This is unnecessary. I didn't respond. Because sometimes the most powerful answer is procedure. And for the first time since that folder slid across the desk, I felt calm. Not because I had won, but because I had chosen the right battlefield. The first official notice from the court arrived on heavy cream paper with the seal of the state of New York pressed into the top corner. It wasn't dramatic, it wasn't flashy, it was procedural. But procedure is power. Margaret called me the afternoon it was issued. We have a preliminary hearing date, she said, 3 weeks. That's fast. They tried to request a delay. The judge denied it. I allowed myself a small breath. For men like Mr. Caldwell, time is a tool. Delay, exhaust, negotiate behind closed doors. But once we filed first, we set the tempo. That night, Andrew showed up at my apartment unannounced. He looked different, not polished, not composed, just tired. You blindsided us, he said quietly. I filed a petition. That's not a blindside, that's the legal process. My father's board is asking questions. About what responsibility? He ran a hand through his hair. You don't understand how these things work. I understand exactly how they work, that's why I filed. He looked at me then, not like I was an inconvenience, but like I was someone he had underestimated. I would have taken care of you, he said. That's the problem, I replied. I don't need to be taken care of. The children need to be protected. There's a difference. When you're in your 20s, love feels like security. When you're in your 40s, you understand security comes from structure. He sat down heavily in a kitchen chair. Dad says you're making a mistake. Your father offered me money to erase his grandchildren. He thought it was practical. So did a lot of men who later regretted their decisions. He didn't argue after that. The following week, Margaret and I prepared for court. She explained what would happen in calm, precise terms. The judge will order DNA testing. That's standard. Then we move into financial disclosure. And if they resist, they can't, not legally. I asked her something that had been on my mind since that first meeting in the Park Avenue office. Why did he go pale? She didn't hesitate. Because once paternity is established, child support isn't negotiated by ego. It's calculated by statute. And with his son's income profile plus trust distributions plus equity compensation, she slid a printed guideline chart across her desk. The projected total over 18 years was significantly higher than $5 million. Even before college contributions, even before healthcare escalations, even before trust protections. He thought he was capping the liability, she said. Instead, he triggered a full audit. That word audit made sense. Not revenge, not scandal. Audit. Accountability under law. The hearing day arrived cold and gray. No cameras, no reporters, just routine. Family court isn't glamorous. The benches are wooden. The air hums faintly from old ventilation systems. When Mr. Caldwell entered, he wore a charcoal suit tailored to perfection. His legal team followed 2 partners from a white shoe firm and a younger associate carrying files. He didn't look at me. Andrew did. The judge, a woman in her late 60s with sharp eyes and a measured tone, reviewed the filings. Petition to establish paternity, she said. Motion for DNA testing. Financial disclosure request. She looked over her glasses. Is there any dispute as to potential paternity? One of Caldwell's attorneys stood. No, Your Honor. No theatrics. No raised voices. Just acknowledgement. The judge ordered DNA testing within 10 days. Then she addressed financial disclosure. Given the income representations provided, she said calmly, the court will require full documentation of salary bonuses, trust income dividends, and equity distributions. I watched Mr. Caldwell's jaw tighten almost imperceptibly. For a man accustomed to privacy, disclosure feels invasive. For a court, it's routine. We will comply, his attorney said. The judge nodded. This court's priority is the welfare of the unborn children. All further motions regarding private arbitration are denied. Denied. That word settled in the room like a final note. After the hearing, Mr. Caldwell approached me directly for the first time since the Park Avenue meeting. You've made this more complicated than necessary, he said evenly. No, I replied. I made it transparent. You could have walked away comfortable. I still will. He held my gaze longer than before. You've forced exposure. I've forced responsibility. For a moment, something flickered in his expression, not anger, not contempt. Recognition. He wasn't dealing with someone intimidated by wealth. He was dealing with someone trained to stand her ground under pressure. As he turned away, I heard one of his attorneys murmur quietly to him, "This will be expensive." Expensive. As if children are line items. Margaret touched my arm gently. You handled that well. I didn't handle anything I said, the court did. And that's when it became clear why filing first mattered so much. Had I gone to that clinic appointment, there would be no court record, no structured support, no legal protection for 2 children who hadn't yet taken their first breath. Instead, there was now a docket number, a judge, a statutory framework. A process bigger than any one man's checkbook. That evening, Margaret called with an update. The financial disclosures are due in 14 days, she said. If they delay, we can move for enforcement. I stood by my apartment window watching the city move below me. I didn't feel triumphant. I felt steady. For the first time, this wasn't about proving a point. It was about setting a precedent for my children, for myself, and maybe even for a man who had spent his life believing money could solve everything quietly. The billionaire had gone pale because he realized something simple. He could control boardrooms. He could influence markets. But he could not control state law. And state law had just stepped into his world. The DNA results came back exactly as everyone expected. Andrew was the father. There was no dramatic gasp in a courtroom, no surprise witness bursting through the doors. Just a lab report filed with the court and entered into record. But that single document changed everything. Once paternity was legally established, the case moved from allegation to obligation. Margaret called me the morning the confirmation was docketed. It's official, she said. Now we move to financial disclosure compliance. And how are they handling it, I asked. They requested a sealed proceeding. I let out a slow breath. Of course they did. Sealing a case limits public access to documents. It protects privacy. It protects reputation. Sometimes that protection is reasonable. Sometimes it's strategic. The judge denied full sealing, Margaret continued. Medical details will be protected. Financials will not. That was the pivot point. For the first time in his career, Mr. Caldwell was facing a courtroom where the rules applied evenly. The financial disclosure packet arrived in stages: salary statements, bonus history, corporate filings, trust summaries. The numbers were substantial. Even conservatively structured, Andrew's annual income placed him in the highest tier under state guidelines. Margaret walked me through it in her office line by line. Under statute, she said, tapping the chart-based support is calculated as a percentage of combined income up to the statutory cap. For high earners, courts often apply discretion above the cap. Meaning, I asked? Meaning the twins won't be raised modestly if their father lives extravagantly. That's something many people misunderstand about child support at high income levels. It isn't punishment. It's parity. Children are entitled to share in the standard of living of both parents. $5 million suddenly looked small. Andrew called that evening. "This is spiraling," he said quietly. "No," I replied, "it's stabilizing. My father's board is concerned about disclosure language. I'm concerned about pediatric healthcare and college tuition." He sighed. "You're enjoying this?" I paused before answering. "No, I'm enduring it. There's a difference. I didn't wake up wanting conflict, I wanted clarity." A week later, we attended the financial compliance conference before the judge. No theatrics, just paperwork and deadlines. The judge reviewed the submitted disclosures. Mr. Caldwell Jr.'s compensation package includes salary, annual bonuses, deferred equity, and trust distributions, she noted. She looked directly at Andrew. "Are these figures complete and accurate?" "Yes, Your Honor." His father shifted slightly beside him. The judge continued. "Given the projected long-term support obligation for twins, the court will order temporary support pending final calculation." Temporary support. Structured, enforceable. Andrew's attorney attempted to pivot. "Your Honor, the parties previously discussed a private settlement." The judge raised a hand gently. "This court prioritizes the interests of the children. Private arrangements cannot override statutory obligations." There it was again. Statutory obligations. Law over leverage. As we exited the courtroom, Mr. Caldwell finally addressed me directly. "You've ensured maximum visibility," he said. "I ensured maximum protection," I replied. "You could have handled this quietly." "I could have handled it invisibly. There's a difference." For the first time, he didn't counter. He simply studied me. "I underestimated you," he said. "Yes," I answered, "you did." That wasn't pride speaking. It was fact. In the following days, something unexpected began to shift. Andrew started asking practical questions. "What kind of pediatrician do you prefer? Have you considered schooling options? What about custody schedules?" These weren't defensive questions, they were participatory. Pressure reveals character. His father had responded with control. Andrew, under the same pressure, began to respond with responsibility. Margaret noticed it too. "He's adjusting," she said. "Sometimes it takes structure to clarify priorities." That's something many of us over 60 have seen firsthand. When accountability enters the room, excuses exit quietly. One afternoon, I received an unexpected call, not from Andrew, but from Mr. Caldwell himself. "I'd like to meet," he said. "In what capacity?" "As a grandfather." That word hung in the air. Grandfather. Not liability. Not scandal. Grandfather. We agreed to meet in Margaret's office, neutral ground. He arrived without his legal team. He looked older. Not frail, not diminished, just reflective. "I built everything from nothing," he began, "and I spent my life protecting it." "I understand protection," I said calmly. "But I confused control with protection," he admitted. That surprised me. He continued, "My instinct was to eliminate risk." "And my instinct," I replied, "was to protect my children from elimination." Silence settled between us. Then he said something I hadn't expected. I was wrong to treat them as a problem. That was the first genuine shift. Not financial. Personal. We discussed structured trust funds for education, healthcare provisions, estate planning adjustments that acknowledged the twins formally. Nothing dramatic. Just responsible. As he stood to leave, he paused. "You filed first," he said quietly. That forced my hand. "Yes." And perhaps he added it forced clarity. When the door closed behind him, Margaret looked at me thoughtfully. "Pressure doesn't always break people," she said. "Sometimes it reforms them." Walking home that evening, I felt something unfamiliar. Not victory. Balance. The case wasn't over. Final calculations still lay ahead. Custody agreements still needed drafting. But the tone had changed. Not because anyone surrendered, but because structure replaced secrecy. The billionaire had gone pale the day he realized he couldn't control the outcome. Now he was beginning to understand he didn't need to. The law wasn't an enemy. It was a framework. And frameworks, when respected, hold families together better than silence ever could. By the time the final support hearing arrived, I was 7 months pregnant. The twins were no longer abstract legal concepts. They kicked at night. They shifted when I tried to sleep. They reminded me quietly and constantly what this had always been about. Family court looked the same as it had weeks earlier. Same wooden benches, same muted conversations, same steady hum of fluorescent lights. But the tone in the room had changed. The financial disclosures had been reviewed, the income streams verified, the trust distributions documented. What had once been speculation was now fact. Margaret sat beside me, flipping through her binder with practiced calm. "Remember," she said softly, "this isn't about punishment, it's about statutory calculation." "I know," I replied. That distinction mattered. Across the aisle, Andrew sat alone at counsel table. His father was present, but seated one row behind, no longer flanked by an army of attorneys. Only one senior partner remained. Pressure had simplified things. When the judge entered, the room stood. She reviewed the file methodically. Paternity established, financial disclosures verified, no dispute as to income accuracy, she summarized. Then she began outlining the calculation. Under state guidelines, a percentage of combined parental income is allocated for child support. For high earners, judges may apply discretion above the statutory cap to ensure children share proportionally in the standard of living. She walked through it carefully. Base obligation. Healthcare coverage. Childcare provisions. Education funding. Life insurance requirements to secure support. Trust structures to protect long-term interests. There was no drama in her voice, only clarity. The projected 18-year total exceeded the original $5 million offer by a significant margin, even before discretionary enhancements. Andrew swallowed visibly. Mr. Caldwell's expression remained composed, but his jaw tightened ever so slightly. The judge then addressed custody. "Have the parties discussed co-parenting arrangements?" Andrew stood. "Yes, Your Honor." His voice was steady. "We propose shared legal custody. Structured visitation initially expanding as appropriate." He glanced briefly toward me. I nodded. This was the first moment the case felt less adversarial. Margaret stood next. "My client agrees contingent upon court-ordered compliance mechanisms." Compliance. Accountability built into the structure. The judge approved the framework subject to final written agreement. Then she said something that stayed with me. "Children are not financial liabilities. They are legal responsibilities. This court exists to ensure those responsibilities are honored." That sentence hung in the air longer than any number discussed that morning. When proceedings concluded, the official support order was entered. Temporary payments would convert into structured monthly support, supplemented by trust contributions earmarked specifically for education and health care. Enforceable. Transparent. Secure. As we exited the courtroom, reporters were absent. No flashing cameras, no headlines. Just paperwork and quiet consequences. Andrew approached me first. "I should have handled this differently," he said. "Yes," I replied, not harshly, just truthfully. I was afraid, he admitted. Of my father, of the board, of looking irresponsible. And now, I'm more afraid of being absent. That was growth. Not perfect, not dramatic, but real. Mr. Caldwell approached last. He looked at me for a long moment before speaking. "I misjudged what strength looks like," he said. "Strength isn't silence," I answered. "No," he agreed, "it isn't." He extended his hand not as a negotiation tactic, but as acknowledgement. I shook it. Not because everything was resolved emotionally, but because accountability had been established legally. That evening, Margaret and I sat in her office reviewing the final order. "You understand," she said, "this wasn't inevitable. Many women take the private settlement." "I know." "Why didn't you?" I thought about it carefully. Because private settlements rely on goodwill. Court orders rely on law. She smiled faintly. And law, she said, outlasts moods. Driving home, I reflected on something that might resonate with many people my age and older. We've lived long enough to see fortunes rise and fall, to see companies collapse, to see reputations evaporate overnight. But court orders endure. Structure endures. The twins will be born into stability, not secrecy. That night, Andrew called again. "Dad wants to set up an educational trust beyond the court minimum," he said. "That's his choice. He says it's the right thing. Then I hope he means it." After we hung up, I stood by the window again, watching the city lights flicker against the dark sky. The $5 million check still sat untouched in the original folder inside my desk drawer. It would expire. The court order would not. I didn't feel victorious. I felt steady. This had never been about humiliating a billionaire. It had been about correcting a miscalculation. He believed money could erase responsibility. Instead, responsibility recalculated the money. And in the quiet aftermath of that hearing, something more important than financial obligation had begun to form. Respect. Not because I forced it, but because I stood still long enough for the law to do its work. The twins were born on a clear October morning. No press, no announcements, just hospital bracelets, soft blankets, and 2 steady cries that sounded stronger than anything that had happened in a courtroom. Andrew was there. He stood awkwardly at first, unsure where to put his hands, unsure how to hold something so small after a lifetime of managing things so large. When the nurse placed his daughter in his arms, something shifted in his face. Not fear. Not calculation. Recognition. Mr. Caldwell arrived later that afternoon. No entourage, no assistant, just a man in his 70s carrying 2 small silver rattles in a department store gift bag. He stood at the foot of the hospital bed and looked down at his grandchildren for a long moment. "They're smaller than I imagined," he said quietly. "Yes," I replied, "that's how babies start." He didn't laugh. He stepped closer. "May I?" he asked. It was the first time he'd asked permission since I met him. I nodded. He held his grandson carefully, almost formally, as if afraid the child might judge him. Hospitals have a way of stripping away hierarchy. In that room there were no board seats, no stock options, no private arbitration clauses. Just 4 adults and 2 newborns. Later, when Andrew stepped out to speak with a nurse, Mr. Caldwell remained by the window. "I've spent 50 years building control," he said without turning around, "and I nearly lost something irreplaceable trying to maintain it." I didn't respond immediately. Age has a way of teaching patience, so does service. "You offered me $5 million, I said finally. "Yes. To erase them. I believed I was preventing scandal. You were preventing responsibility." He nodded once. "That is true." There was no defensiveness in his voice. Only fatigue. He turned to face me. "When you filed first," he said, "I was furious." "I know." I went pale because I realized I wasn't negotiating. I was accountable. That was the word he hadn't used before. Accountable. "I confused power with immunity," he continued. "They are not the same." "No," I said, "they aren't." He walked back to the hospital bassinet and looked down again. "I've instructed my attorneys to revise my estate plan," he said. "The twins will be named beneficiaries, directly, not through Andrew." That surprised me. "You don't have to do that," I said. "I know." Silence settled gently between us. "I was wrong," he said again, softer this time. There's a certain weight to hearing those words from someone who rarely says them. "I didn't file to punish you," I said. "I understand that now." He adjusted the blanket around his grandson's shoulder with unexpected care. "I built my life believing problems disappear if you pay enough," he said. "You taught me something different." "I didn't teach you," I replied. "The law did." He allowed himself the smallest smile. "Yes," he said, "it did." In the weeks that followed, something steady began to form. Not friendship, not forgiveness overnight, but structure. Andrew moved into a nearby apartment. We worked out custody schedules without hostility. Pediatric appointments were shared. Holidays were discussed rather than argued. Mr. Caldwell attended the twins' first pediatric checkup quietly. No press, no announcement, just a grandfather holding a diaper bag that probably cost more than my first car. One afternoon he asked to speak with me privately. We met at Margaret's office again. He sat across from me without his legal team. "I'd like to establish a charitable foundation," he said. "For what purpose?" "Veterans' child care assistance, for single service members." I studied him carefully. "Why?" "Because I realized how easily I dismissed what I did not understand." He folded his hands. "You served this country, and I treated you like a risk to be managed." I didn't soften at that. "I won't apologize for protecting my children," I said. "You shouldn't." The foundation paperwork was filed within months, quietly. No branding campaign, no gala announcement. Just funding. Margaret later told me something I hadn't known. When you filed, she said his attorneys prepared for war. And now they're restructuring legacy. That's the thing about accountability. It doesn't just correct behavior. It recalibrates perspective. The $5 million check expired in my desk drawer. I never deposited it. It represented silence. The court order represented security. And over time, even Mr. Caldwell began to acknowledge that security was worth more. On the twins' first birthday, we gathered in Andrew's apartment. Balloons, cupcakes, no photographers. Mr. Caldwell knelt carefully on the floor in his tailored slacks, while my daughter grabbed his tie and refused to let go. He didn't correct her. He laughed. That sound was new. Not polished. Not controlled. Just human. Later that evening, as the guests left, he stood beside me near the doorway. "You were right to file first," he said quietly. "I was right to file for them," I corrected. "Yes," he agreed, "you were." There are moments in life when revenge would be easy. Public humiliation. Financial escalation. Escalation of conflict. But I've learned something over decades of service and living. The most powerful form of justice isn't destruction. It's correction. The billionaire went pale because he believed he was losing control. What he was actually losing was illusion. And sometimes losing illusion is the first step toward becoming something better. It's been 6 years now. The twins are in first grade. They argue over cereal choices and insist on tying their own shoes even when they don't quite get the knots right. They don't know anything about Park Avenue offices or non-disclosure agreements. They don't remember a time before structure. And that's exactly the point. We live in a modest brownstone in Brooklyn. Not extravagant, not headline-worthy, just stable. Andrew moved 2 blocks away when the twins turned 3. Shared custody became routine. Wednesday dinners, alternating weekends, school concerts attended without tension. The court order remains in place, quietly doing its job. Automatic transfers, educational trust contributions, healthcare coverage, life insurance policies naming the twins as beneficiaries. No drama. Just consistency. Mr. Caldwell visits once a week. He arrives without announcement, now usually carrying something small, library books. A puzzle, once a model airplane kit, he insisted on assembling with far more precision than necessary. The first time my son called him Grandpa, he froze. Not in discomfort. In recognition. I saw it in his eyes, the weight of what almost didn't exist. One evening after the twins were asleep, he and I sat at the kitchen table with cups of tea. No legal binders between us, no folders sliding across polished desks. "I used to believe privacy meant strength," he said. And now I asked. Now I understand transparency is what holds families together. Age has a way of sanding down arrogance. "I can't undo what I tried to do," he continued, "but I can decide who I am going forward." "That's all any of us can do," I replied. The Veterans Child Care Foundation he established has grown quietly over the past few years. It now supports dozens of single service members who would otherwise struggle to balance duty and parenting. No press tours, no naming rights. Just assistance. Margaret still checks in once a year to review trust documents and ensure everything remains compliant. She calls it preventive law. I call it peace of mind. The $5 million check is long gone, shredded when it expired. I kept a photocopy for a while, not out of resentment, but as a reminder. A reminder of how easily silence can be purchased. And how much more valuable protection is. Andrew has changed too. Responsibility reshaped him. He coaches Little League on Saturdays. He shows up early to parent-teacher conferences. He no longer looks over his shoulder before making decisions. He makes them. Once during a quiet moment after a school play, he turned to me and said I was afraid of disappointing my father. And now I asked, "Now I'm more afraid of disappointing them." He nodded toward the twins. That's growth. Not dramatic. Not cinematic. But steady. I've thought often about the day Mr. Caldwell went pale. At the time I assumed it was shock. Now I understand it was recognition. Recognition that influence has limits. Recognition that accountability isn't optional. Recognition that control is not the same as care. For those of us who have lived long enough to see the arc of our own mistakes, there's something comforting in that. The law didn't humiliate him. It clarified him. And it clarified me too. I didn't file to win. I filed because in America showing up matters. Filing first matters. Understanding your rights matters. Especially for women. Especially for service members. especially for anyone who has ever been told it would be easier if you just walked away. Sometimes walking away is strength, but sometimes standing still is stronger. If you're listening to this and you've ever been pressured into silence, financial, emotional, or otherwise, know this. Structure is not aggression. Accountability is not revenge. And protection is not selfish. It's responsible. The twins don't know the details of how their lives began in a courtroom. They just know they are wanted. Legally. Emotionally. Fully. Mr. Caldwell still moves with measured precision, but when my daughter runs into his arms, he doesn't calculate. He holds. That's the difference between control and connection. If this story resonates with you, if you've ever faced a moment where doing the quiet right thing felt harder than taking the easy payout, I invite you to reflect on it. Share it with someone who might need the reminder. And if you believe stories about responsibility, dignity, and lawful strength still matter in this country, consider subscribing and staying with us. Because sometimes the most powerful victories aren't loud. They're structured. They're steady. And they endure.